A federal appeals court blocked the immediate release of hundreds of immigrants detained during a Chicago area immigration crackdown. The court also allowed the extension of a consent decree outlining how federal immigration agents can make warrantless arrests. The 7th U.S. Circuit Court of Appeals heard arguments last week about the 2022 agreement governing how U.S. Immigration and Customs Enforcement can arrest immigrants besides those being specifically targeted in an operation. The consent decree has been in the spotlight amid the Trump administration's Chicago area immigration crackdown that's led to more than 4,000 arrests. Last month, U.S. District Judge Jeffrey Cummings, who found the government violated the agreement, ordered the release of more than 600 immigrants on bond, which the appeals court paused. Roughly 450 remain in custody, attorneys say. In the 2-to-1 opinion, the appeals court said Cummings overstepped his authority on the blanket release of the detainees without assessing each case individually. The consent decree carefully maps out what the district judge can or cannot order to balance enforcement and public safety, according to the opinion. But the ruling also said the Trump administration wrongly categorized all immigrant arrestees as subject to mandatory detention. On December 11th, a dramatic clash unfolded on Capitol Hill as Senator Jack Reed confronted a top Pentagon official over President Trump's alleged authorization of military operations inside the United States.
The National Guard has been deployed on numerous occasions, but these circumstances seem somewhat unique. And in addition to that, the Secretary of Defense has just ordered the National Guard to create a response force and a nationwide deployable quick reaction force. These forces, let me ask Mr. Dittleson, what is the purpose of these forces, Mr. Dittleson?
Thank you for the question, Mr. Ranking Member. These two situations, the National Guard Response Force and the National Guard Quick Response Force, are already pre-existing functions that are being reorganized and re-equipped to a higher level and modernized to be able to serve their functions better. So these are already existing capabilities within the National Guard, and we're just changing the manner in which they are task organized to be more effective.
So there's no change in mission?
There's no change in mission, that's correct.
So they have to respect the Posse Comitatus Act and not become enforcers of domestic law?
If they are employed in Title 10 status, that is correct, sir.
And Title 32 status would require the concurrence of the governor or not?
That is correct.
Okay. There is when this program was rolled out, Mr. Young, there was a suggestion that one of its main purposes is deterrence, which touches upon a basic right of Americans to come together peacefully and demonstrate in cities and towns across the country. But this deterrence effect, one could argue, could inhibit or is designed effectively to inhibit those assemblies. Would that be constitutional?
Mr. Ranking Member, thank you for the question. I think the presence of National Guard personnel at federal locations is designed to protect those federal property and functions from violence, from the threat of burning a building, of officers being harmed in the execution of their functions, or the impedance of those federal functions. Those functions do not impede in any way or deter people from exercising a valid constitutional right to protest. Obviously, people have protested throughout the history and course of our country in many ways. When they go beyond what is a legal protest and cross the line into violence against federal officials in the execution of that protest, the design for the deployment of these National Guard personnel is to simply protect the federal functions and the personnel that are being harmed.
So you would concur with Judge Breyer in the California federal courts, who declared the actions of National Guard and other military as unconstitutional. I believe one of the areas that they were protecting was MacArthur Park, which is not a federal facility, or at least they were making sweeps to MacArthur Park. But you concur with Judge Breyer's conclusion that the president acted unconstitutionally?
No, Senator, I would say that I concur with the Ninth Circuit's decision that the president acted lawfully, and I disagree with the district court's decision. I respect the district court's decision, and it's my understanding that the actions in MacArthur Park were designed to protect the federal officers that were otherwise there, that were not uniformed military personnel, that were performing a valid legal federal function.
Thank you. General Guyot, first of all, thank you for your service and your very difficult job of maintaining a balance between your military responsibilities and many of the orders you're given. If you were, if the president declared an organization a terrorist organization or a DTO, which is on a secret list, and you were ordered to attack them on U.S. soil, would you carry out that order?
Senator Reed, as with any order I get, I would assess the order, consult the legal authorities to ensure that it was a lawful order, and I would, if I had questions, I would elevate that to the chairman and the secretary, as they welcome at all times. And if I had no concerns and I was confident in the lawful order, I would definitely execute that order.
You were at Quantico when the president addressed the officers.
I was, sir.
So he said there's an enemy within. And he also said that to these officers, you included, you're going to be a major part for some of the people in this room. That's a war too. It's a war from within. The president essentially indicated that you should be prepared to conduct military operations in the United States against this enemy within. Are you doing that?
Sir, I've not been tasked to do anything that reflects what you just said.
Do you have any indication of who this enemy within is?
Sir, I do not have any indications of an enemy within. We maintain readiness to execute the orders, both to defend the homeland in many ways, but I have not been tasked in that way.
Well, I would assume that the enemy within does not include the thousands of people who attacked the Capitol and were later pardoned by President Trump. So it must be some other group of Americans. Thank you.
General Gio, you've been on the job since last year. Have you received any illegal orders this year?
Senator, I've never received any illegal orders throughout my career.
Never once in your entire career?
I have never.
You've been around for a while, haven't you?
Yes, sir, I have.
Okay. Mr. Young, I'll just continue down that order. I mean, you have lawyers to make sure that people act lawfully. That's why our combatant commanders have JAGs, why the president has lawyers, why this committee has lawyers, why business executive has lawyers. And isn't it the case that non-lawyers, laymen, don't always know what the law is? Is that so?
Yes, Senator, that's true.
And in your long and illustrious career as a lawyer, I'm sure you've had a client who's asked you whether some course of action is lawful or not, and you've had to tell them, no, that's not lawful, right?
Most certainly, Senator.
And that's why we have lawyers around, is to help inform the decisions of responsible persons who are laymen and who are not actually lawyers, right?
Yes, Senator.
Is there a presumption of lawfulness of orders in the military?
Yes, sir. Yes, sir. There is a presumption of lawfulness, not only in the Uniform Code of Military Justice, but the Supreme Court precedents that's long established, going back more than 150 years, says that whenever a statutory authority is given to the president, that it's presumed that he is acting in accordance with that law. And longstanding Supreme Court precedent that deals with the necessity for a valid presumption of lawfulness in an order that's issued by the president.